Court rise. Appeal in the matter of Soleymani and Nifty Gateway LLC.
Yes, Mr. Dunn.
My Lord, I appear together with Miss Angeline Welsh for the appellant, Mr. Amir Soleymani, who's sitting at the back of the court. It's common ground that Mr. Soleymani is a resident of and domiciled in Liverpool. He came to this country from Iran and he was granted asylum as a political refugee in 2011. He's explained in his witness statement that he's a wealthy individual who inherited money.
Just before you launch in on the substance, can I just ask, have you agreed between yourselves an allocation of time?
We haven't, my Lord. I mean, you've seen, I hope, that there was a letter sent to the court.
I've seen that.
A time estimate.
Speaking
to that, it's not possible to know precisely how long we've got.
All right. Well, the answer is you've got a maximum of 2 days. We all think it shouldn't take that long. We've all read a good deal and discussed it, so that obviously you can take us to the underlying materials, but we may hurry you on if we're familiar with them. It strikes me that an equitable allocation of time would be half the time each. We would. I don't know whether Mr. Riley Smith is proposing to say anything, but we may have some questions for him, and we'd perhaps like to factor in perhaps 20 minutes for that, and otherwise you can have half the time each, and you can split your time between opening and reply as you think necessary.
I'm answering for Mr. Riley Smith. I know that he's not planning to say anything unless invited to do so.
Right. So you've got half the time minus 20 minutes.
Yeah. I'm grateful, my Lord. Now, just very briefly, because this is featured in the respondent skeleton argument, it is the case that Mr. Soleymani is a wealthy individual who inherited money and has also made money by his own efforts in the digital world, including through cryptocurrency holdings, and he does hold substantial investments. And in his witness statement, he's described himself as an entrepreneur, an activist, and a philanthropist, and that's paragraphs 8, 9, and 13. And for what it's worth, he tells me that he has no connection whatsoever with the US. He is, of course, Iranian. He's never been to the US in his life, and he may well.
Is any of this in the evidence?
My Lord, what I'm just going to say, I'm getting these points out of the way because we say the relevant test is entirely objective, and these matters don't matter. So if one is applying the CRA, for example, it's an objective test. It doesn't matter whether.
So in your case, it doesn't matter, and if you're wrong about that, you'd like us to take into account something that isn't in the evidence.
You don't need to take it into account, my Lord. But I just thought I would say it anyway. And equally, we say it's an objective test for the CRA. These matters do not matter whether he's wealthy or otherwise. What his status is so far as being able to go to New York or not being able to go to New York. Nor are they relevant to the CJJA issues or to the arbitration exception issue. So I just wanted to get those points, as it were. We acknowledge them in terms of his wealth and so on, and that's no doubt how he can afford to fund a case in the Court of Appeal. But we say that these are not relevant facts to the issues that you actually have to decide. Now, my learned friends, Mr. David Lewis and Mr. Andrew Feld, appear for the respondent Nifty Gateway LLC. This is a Delaware corporate body which seems to be physically operated from offices in New York City, although as far as can be ascertained, it's not actually regulated anywhere in the world. It's one of the leading platforms in the world for the auction and sale and holding of digital assets and artwork known as non-fungible tokens, or NFTs for short. And it is understood that its business turns over very large sums of money. And as you know, Mr. Riley Smith appears for the CMA, and he's been permitted to intervene by the order at tab 12 in the court bundle, and he's submitted a skeleton argument. I'm not going to say very much about the facts, particularly in view of your Lordship's indications, but just very briefly to summarise the facts. Mr. Soleymani joined the respondent's platform in late February 2020, and by the end of April 2021, when the relevant auction with which this case is concerned took place, he had participated in quite a few auctions on the respondent's platform, around 23, according to the evidence in Wedding 1, paragraph 16. And that's in tab 8, page 59. In total, through the platform of the respondents, he bought somewhere between, the numbers don't exactly tally in the evidence, but somewhere between 102 and 106 NFTs. Now, around 9 of those were through winning bids by placing the highest bid in an auction, and the rest were by direct purchases from sellers, but conducted via the Nifty platform. And that's in Soleymani 1, paragraph 26, tab 9, page 85, and Wedding 1, paragraph 16, supplemental appeal bundle, tab 16, page 59. And what happened in this case is that Mr. Soleymani put in a witness statement in opposition to the application which was made contesting jurisdiction. And he said he doesn't trade in NFTs or digital artwork. He's a buyer and a collector. And on the very few occasions when he has sold NFTs, he's done so for charity, donating the sale proceeds to charity. That was Soleymani 1, paragraph 19a, supplemental appeal bundle, tab 9, page 76. He also says he does have an art gallery, but it's not an art gallery for buying and selling art. It's a private gallery for display only, and it's not a place where sales are made, and in any event, it doesn't contain any NFTs or digital artwork. And that's Soleymani 1 at paragraph 19b, supplemental appeal bundle, tab 9, page 76. Now, after seeing that evidence, at the hearing below, a concession was made by the respondent, and it was common ground for the purposes of the application before the court, including for the purposes of the CRA and the CJJA, or otherwise, that Mr. Soleymani is to be regarded as a consumer under English law, and that common ground is recorded in 2 places in the judgment, both paragraph 40 and paragraph 102, where it is made clear that that extends to the stay application as well as to the... should I take your lordship to that?
Yes, because I think what you're saying now is controversial, isn't it?
So paragraph 40, first of all, which is on page 109, tab 9. For the purpose of this application, it's not necessary to investigate whether the claimant acted in the capacity of a consumer within the meaning of the CJJA or the CRA 2015 or otherwise at the material times. This is because the defendant does not take the point for the purposes of its application that the claimant was not a consumer. This was a sensible concession reflecting the available evidence on a jurisdictional objection, and it was notable that in the New York arbitration, he is being treated as a consumer. However, the defendant made it clear that it reserved its position on this question should the substantive merits of the claimant's claim need to be determined, and it did in this application dispute that it was a party to a consumer contract within the meaning of section 15E of the CJJA. And then the judge came back to this point later in the judgment at paragraph 102 and said, that is on page 128, the claimant has shown plausible evidence that any contract he concluded with the defendant was a consumer contract and has not conceded that the claimant was a consumer for the purpose of this application to challenge jurisdiction or seek a stay. This was a useful concession, as many of the points were questions of law, for example, as the scope of the arbitration exception in the recast regulation. However, the defendant made clear that it reserved its position on this question should the substantive merits of the claimant's claim ever need to be determined. So for the purposes of the application, which was the subject of the judgment, including the stay aspect, and for all purposes connected with the application before the court, it was conceded that the the claimant rather, was, the appellant, was a consumer, whether under the CJJA or the CRA or otherwise. Now, my Lord, I'll say this now and I may need to come back to it, but our position is that that concession necessarily extends to the section 9.4 aspect of the respondent's application, because it's part and parcel of the respondent's application for a stay that the court has to determine the question under section 9.4. Alternatively, we say, in any event, the section 9.4 matter should be decided on the current evidence because the respondent had the opportunity to submit reply evidence and chose not to do so, and there's some correspondence on this we may need to go to in due course. But the point is that a person in the position of the respondent cannot improve its position on an application by purporting to reserve its right to serve further evidence if the matter has to be determined as a matter of substance, if that is a matter which has to be determined on the application itself. In other words, one can't make a reservation and thereby, if you don't choose to serve any reply evidence, improve your position. That, I hope, deals sufficiently for present purposes with the concession, and maybe that my learned friend will say more about that. Now, just very briefly on the underlying dispute, just so that the court understands what's at stake. The auction which has given rise to this dispute was an auction unlike any other that Mr. Soleymani had previously participated on the Nifty platform. Now, it was for an artwork called Abundance by the artist called Beeple, that's B-E-E-P-L-E. All other auctions had been what I would call, in my language, standard winning bid auctions, whereby you placed the highest bid and you got the thing that was the subject of the auction. But this auction was not conducted like that. It was apparently termed a ranked auction, and it turned out that the rules of this auction was that the 100 highest bidders would all receive something, right down to the 100th, who would get something to say that they'd bid the 100th highest bid in the auction. And they would be, what they got in terms of the NFT was ranked according to the size of their final bids. And the effect was that the auction house, or ultimately the artist, kept the total sum of the 100 highest bids. And Mr. Soleymani has described this in his witness statement, paragraph 30, and that's in Supplemental Appeal Bundle, tab 9, page 85. I don't think we need to go to it. But as far as this is known, this was the very first occasion on which the respondent had ever conducted an auction like this. It took place over 3 days between the 30th of April 2021 and the 2nd of May 2021. It's Mr. Soleymani 1, paragraph 29, tab 9, page 85. Now, Mr. Soleymani has said that he's never come across an auction conducted like that, and that he made his bid of the $650,000 equivalent in Ethereum, or whichever cryptocurrency it was, believing that he was bidding for a single NFT that the winning bid would get and all the other bids would get nothing. And that's in Soleymani 1, paragraph 31, Supplemental Appeal, Bundle tab 9, page 86. Now, On the screen for this auction, at the top of the page, when you looked at the screen, there was something that said ranked auction. And next to that was an I, letter I. And it turns out that if you clicked on the letter I, you were then taken to another page which says, how does it work? And that contained a description of this new form of auction, which was unlike any other that had taken place on the platform before. And Mr. Soleymani's description of all of that is in paragraphs 33 to 35 of his witness statement, supplemental appeal bundle, tab I've just given, tab 9 at page 86. Now, in order to participate in the auction, one was not required to click on that link to how does it work. And he says he didn't do so, and the link was not prominently displayed. And after having participated in some 20 or so prior highest bid auctions, he simply assumed that he knew how the auctions worked and that this was the same as the previous auction. And he didn't register the link and didn't click on it and didn't realise that this was something different. So that is why there is a dispute. That's the underlying dispute. I needn't say anything more about it.
Those are all points that go to whether he ought to have to pay the 650,000.
Yeah, exactly.
And
that's
not a question.
and I just wanted the court to know what was sitting in the background. The court doesn't need to make any findings on that, but it's just a point of information.
And the English court isn't concerned with that because it's no part of his claims in front of the English court to decide those questions of substantive liability.
Not as the claims stand at the moment. I mean, it's possible, I suppose, depending on how this case goes, that he might seek permission to amend. But at the moment, that's certainly the case. That it's
he's not asking the English court to decide his substantive rights and liabilities to pay the 650,000. Is that right?
Other than to in relation to the Gambling Act.
Other than in relation to the Gambling Act.
That is correct. Well, although I mean, I don't know whether. He's asking for a declaration that the arbitration agreement is not valid or not binding, depending on which statute one comes under. And he's asking for a determination that the choice of law provision is not binding or invalid. And he's asking for the relief under the Gambling Act. Those are the three claims. And that is the extent of the claims at the moment. Obviously, it is not impossible that he might seek to amend if he wins on jurisdiction. But I can't say any more than that at the moment.
Would it have been open to him to bring a claim for a declaration of non-liability for the 650,000?
It would. And it would have been subject to the same objection, not in terms of the arbitration exception,
no,
but in terms of the stay. It would have been subject to the same objection. So the same issue would have risen.
Well, in relation to the stay, but but it wouldn't, on the judge's findings, give rise to any jurisdictional difficulty. There wouldn't be an arbitration exception that applied to it, and there'd be jurisdiction here under the regulation as well as Section 15B now.
And he has applied for a declaration that the arbitration agreement is invalid or not binding, whichever provision one goes under.
But it's that declaration which engages the dispute on jurisdiction. It is,
and that's the interesting. Well, I think it's an interesting point that has to be decided. Although I will be suggesting that the answer is actually very simple, but I'll come to it in a moment.
But the reason I raise that is that we'll need to keep sight of what the consequences are for other consumers and so on. And we're not here dealing with a problem for jurisdiction where a consumer seeks to have vindicated his substantive rights and liabilities under the
well, that's
Act.
true, except that
save insofar as Section 9 is applied to send those questions back to the arbitrator as opposed to be decided here. But from the point of view of the jurisdictional gateway, nothing we decide will affect consumers who are actually seeking to have their substantive rights and obligations
Well, unless
Sorry.
they are also seeking a declaration, because it would not have been possible to seek a declaration that the arbitration agreement is void or not binding, and that no money is due. It doesn't have to be one or the other. It's not a choice between seeking a declaration between the arbitration agreement not being binding or seeking a substantive declaration on the merits of the 650 claim. Could have done both. But as I say, that it's not impossible that my client will, if he wins on this case, would seek to amend. Even if he doesn't. If he only wins on the Section 9.4 aspect, he might seek to amend. So, although you're right that my client hasn't pleaded that at the moment, it is not impossible that my client would be able to plead it, because he would be able to establish jurisdiction for that. I would say this, that I wasn't involved when the drafting was done of the particulars of claim, but I do understand it was done in a hurry. And that sometimes people do amend claims subsequently to claims when they've thought more about it. But this case has been contested on the basis of the existing pleading. But I would simply ask the court to bear in mind that it would be open to my client to bring a claim for a declaration that he's not liable for the 650k or whatever, however it's being debited. It's very complicated how it's actually been done, apparently. But in essence, it doesn't matter how one phrases it. And then the same issue would arise in relation to the stay. And that point, therefore, if that point is decided in my client's favour in relation to the stay, he may well seek to amend in due course. Or he may seek, if he wins on these issues, he may seek an anti-suit injunction, like the claimant did in the Semengo-Turner case. I don't know if your Lordship had a chance to look at that.
No, I think for myself, I'm going to need your assistance on that.
I'm only put that in the bundle because that is there are two special areas of protection under what was the regulation, now the Civil Jurisdiction Judgments Act. One is for consumers, and the other is for employees, and they are treated broadly the same. So 15b(6), for example, applies to both consumers and to employees. And that was a case where, and I'll take you to it in due course if we need to, but just put it in as a parallel. This court, the Court of Appeal, held, Lord Justice Tuckey gave the leading judgment, that an employee had a right to be sued in this jurisdiction. And that although one of the parts of his employment contract was a bonus contract, he was an insurance broker with one of the US insurance brokerages, Marsh McLennan, or I forget which. Though his bonus contract contained a New York jurisdiction clause, exclusive jurisdiction clause, that infringed his rights as an employee to be sued in this country. And you'll see if you go, it's only really paragraph 42, it's particularly relevant on this, but that Lord Justice Tuckey said in that case that the only way to give effect to the employee's right to be sued in this jurisdiction was because the New York court had already held that it had jurisdiction under its exclusive jurisdiction clause to grant an anti-suit injunction against the person bringing those proceedings, the company in the group that was bringing those proceedings, so that protected the employee's right to be sued in this jurisdiction. Now, it wasn't an arbitration agreement case; it was a jurisdiction clause case, but it is a parallel, and it's not beyond the realms of possibility that if my clients were to win this case, that they might seek an anti-suit injunction, amend their claim to seek an anti-suit injunction to restrain the New York arbitration. Because as Lord Justice Tuckey said in paragraph 42 in that case, that the injunction was the only way, once the court had decided it had jurisdiction, to give effect to the employee's statutory right to sue and be sued in this jurisdiction. So that's why I put that in, my lord, and I can take you through it briefly if I need to, but I hope I've summarised it accurately.
You haven't said it was 43, not 42.
My memory has failed me there. It is almost the final paragraph anyway. I think you found it. The other thing I was going to show you, if necessary, was the contractual terms, but it may be that you've already gone through those very closely and marked them up. But the relevant terms, the most directly relevant terms, and this is in tab 3 of the supplemental appeal bundle, are clause 1, this is on page 19 in the bundle, and all 3 paragraphs there are relevant. And you'll see that it makes reference to the arbitration clause.
Yes.
Then clause 16, which is the choice of the governing law provision, which is at the top of page 31. These terms of use, your use of Gemini, your rights and obligations, and all actions contemplated by and arising out of or related to these terms of use shall be governed by the laws of the State of New York, as if these terms of use are a contract wholly entered into and wholly performed within the State of New York. You understand and agree that your use of Nifty Gateway as contemplated by these terms of use shall be deemed to have occurred in the State of New York, and be subject to the internal laws of the State of New York without regard to its conflicts of laws provisions, and that's all in capitals. And then the disputes provision, clause 17, and I think probably all the paragraphs of this are relevant.
Yes, I think we've all looked at this.
Yeah, and so I'll pause there. Now, other terms which are not directly relevant, but which are quite one-sided, if one's looking at this from the consumer rights perspective, are clauses 8, 10, 23, 13, 14, and 15. I don't think I need to take you to those there.
What's the relevance of that?
They're not directly relevant, but they're part of what looks like quite a one-sided set of provisions. That's all. Now, what I've just shown you were the terms when he joined the platform, my lord. The terms were updated, I think, just before, possibly the night before the auction started. So the April 21 terms are in tab 4 of the bundle. There is no material difference for present purposes. And in fact, the only difference is that there was an entirely new clause 7 was added, which has the effect that the subsequent clauses are renumbered. So the choice of law provision 16 becomes 17, and the arbitration clause 17 becomes 18. And that's all you really need to know about that. Now, we respectfully submit that the learned judge was wrong on jurisdiction, that she should have held that the arbitration exception in the recast regulation does not apply to the arbitration agreement claim. And whether or not she was wrong on that point, she was wrong in principle in a consumer case like this to have ordered a stay. She should either have decided on the existing material that the arbitration agreement was not effective or was void, or at the very least should have ordered a preliminary issue to be tried by the English court as to whether it or not it was.
Can I just ask you about that second possibility? What are the practicalities involved? Has the timetabling order of the arbitrator meant that the evidence could be dealt with fairly swiftly and that could be determined by the English court in advance of the September hearing or not?
Well, one of my submissions, which I was going to come to, is that it's actually a very simple matter to decide that a clause such as this is unfair objectively. If one looks at the decisions in the cases which have made a decision on this, either fair or unfair, each of the decisions is very short in terms of its reasoning. The average is about 4 paragraphs. I think Mr. Justice David Steele dealt with it in less than a page in the case that he was involved in. And you'll see that in the origin of all of this is the Gruppo, the Oceano Gruppo, I think it's called, case of the European Court in 2000. They dealt with it in only 3 paragraphs. It's not a complicated thing once one takes on board that it's an objective decision, which has been stressed in the Cavendish case by our Supreme Court recently in relation to, obviously to arbitration clauses, but in relation to the CRA generally.
Well, I understand you say we can and should decide it on the material we've got.
Yes.
On your fallback position, that at least it should be the subject matter of a trial of an issue here.
Yeah.
Is it your case that that can easily be done in advance of the hearing in September?
Well, I certainly wouldn't say it could be done easily. Obviously, the reason why this appeal was expedited was so that there would be a decision, hopefully, before on these issues before the hearing before the arbitrator, which is due to commence on the 13th and then on to the 14th of September. It could be done in September, but it would need to be an expedited trial.
And is that what you would be seeking, or would you be saying we'll go to the arbitrator and ask him to defer the evidentiary hearing?
Well, I may well be seeking that as my primary case, and the fallback might be to ask the arbitrator to adjourn it.
So
I am going to try to persuade you that it's a matter that you can.
Of course, I understand that, but just so I can see the landscape on your fallback position.
Yep.
What you anticipate is primary, get it decided here before September. Alternatively, if it can't be decided here before September, get the arbitration adjourned.
Yeah, and there's a third alternative, which is this court has decided it will decide the point, but hasn't yet produced its judgment. And in which case we would, if that is the way, if the court already knows by the end of this hearing that's the way that it's going to go, then we would ask for an indication as to when that judgment might be, even if it's 1st of October or whatever. We can then tell the arbitrator that it's coming. But if the court feels that it can't decide the point, then we would ask for, but the English court must decide the point because of section 71 subsection 2, which is a critical feature of this case, and I'll be coming back to that. Then we would ask for it to be expedited if possible, or as soon as possible, and then we could go to the arbitrator and explain to him whether or not it's expedited, that we're doing our very best to have it determined by the English court as soon as possible.
Thank you.
My Lord, there was one other point that, again, you'll say to me, is this in the evidence? And it's not in the evidence. But I wanted to give your Lordship some idea of why these points are important, not just to my client. Can I just give you a few things? And these are points of information. I'm not asking you to make any findings on them. But the first is that I understand that there was recently a survey in the UK of the UK population, and 3.3% of the population said that they were planning to own an NFT in the future. That's equivalent to 1.7 million people. Secondly, and this is perhaps more germane to this particular case, there have been, in the last week, my Lord, depositions in support of the New York arbitration. And in one of those depositions, the person deposed was Thomas Kimmelman, the respondent's employee, and he testified that the UK is one of the respondent's 3 largest markets alongside the USA and Canada, and he said that the respondent's total customer base in the world was between 1 million and 2 million people, and that around 10% of that customer base was located in the UK. Now that translates to saying that...
So the customer base was what?
Between 1 and 2 million people worldwide, with 10% located in the UK. So, in other words, 100,000 to 200,000 customers in the UK. That was his testimony on deposition.
Customer base here meaning people who've accessed the website rather than those who bought or sold.
They may or may not have bought or sold, but they've registered themselves on the website. Right. And the other thing I would say, and again, I'm not asking for findings, but our understanding is that most of the leading NFT platforms include a similar New York arbitration and choice of law clause in their standard terms. So for those reasons, and it may be I didn't need to say this, but that we respectfully submit that the decision below of the judge first instance would have substantial negative implications for possibly a very large number of NFT customers or consumers domiciled in the UK.
Are the points limited to NFT purchases?
Well, I'm going to come to that, but it's just starting with NFT, my lord. We're talking about potentially hundreds of thousands and possibly hundreds of thousands of people. And it isn't just limited to NFT, but NFT is a huge market. It's a surprise to me, but apparently the largest NFT platform is called OpenSea, and its turnover last year in 2021 was 31 billion on its platform. So it sounds very high, but it's a huge industry, this. But I do take the point that, so the point I was making was even if this case is restricted to NFT dealing, most of the leading NFT platforms have the same terms as far as we know. And even if it's restricted just to Nifty, they seem to have 100,000 custom consumers or potential consumers in the UK. But it isn't restricted, as my Lord Justice Snowden says, just to NFT. It can happen in relation to other forms of internet dealing. Of course, I'm not suggesting it applies to, say, Amazon or some of these, because the way they work is that they have a UK registered company involved, and then that company is subject to the UK legislation. But I don't want to overdo this point and say that it applies to everything that's bought and sold on the internet. That isn't the case. But it certainly does apply in relation to a very big industry, the NFT industry.
I think you'll find that Amazon may well have, for example, a UK base, but it also direct sells from the US operation as well.
Yes, and of course a lot of its sales are not with Amazon. They're with a customer who's simply using it as a platform as well. Just before we go any further, there's one other issue with arbitration for consumer cases, and that is that arbitrations are confidential. And that means that if there are wide-scale market abuses, they can go undetected. And I don't know if you noticed, but in clause 17 of the arbitration agreement in this particular case, there is an exclusion of class arbitrations in the antepenultimate paragraph. That's on page 32 of tab 3 of the supplemental appeal bundle. So we certainly submit that Lord Justice Mayles was entirely right to say that this appeal raises points, I'm quoting, of some general importance concerning consumer protection for consumers domiciled in England. And it's arguable that there's a real prospect of success, that the judge's approach was wrong in principle, we say that he was right on both points. And the key point, if I may say so, in this case, and one of which the learned judge below did make reference to, but hasn't really dominated her reasoning, if it use that phrase, is that the overriding reason why this case is different from the normal commercial arm's length contract containing an arbitration clause is that this case is located in a field where there is a package of mandatory legal protection for consumers domiciled within the UK. And it's the mandatory feature which is important. We're not in an area of freedom of contract. And that means that so far as the English courts are concerned, and of course this court has to apply mandatory English law, as did the court below, it is not possible to contract out of that protection because allowing that to happen would defeat the legislative purpose. And what I would like to do before I go to develop the submissions, I thought it would be helpful just to summarise the relevant 9 features of this mandatory consumer protection, which you will have seen reference to, but I thought it'd be better to pull it together into one place. So, a UK domiciled consumer generally benefits under English law, or in fact it's UK law, but I'll say English law, but it is in fact UK law, from the following package of statutory protections, which has at least 9 features. And if I may, I'll just list them. First of all, a right to sue the other party to a consumer contract in the courts of the part of the UK where he or she is domiciled. And that is CJJA section 15B2. I can give you the references, but I don't know if I need to recall them. Secondly, the right to be sued by the other party to a consumer contract in the courts of the part of the UK where he or she is domiciled. And that's section 15B brackets 3 of the CJJA. Thirdly, the provision in 15B6 of the CJJA that the 2 rights that I've just described in 15B2 and 3 to be sued and to sue in the customer's place of domicile may be departed from only by certain types of agreement, and in particular and relevant for present purposes, by a post-dispute agreement. And that provision, 15B6, is the equivalent of Article 19 of the recast regulation. Fourthly, in addition to that, it is then expressly declared in 15D1 that agreements conferring jurisdiction shall have no force under English law if they are contrary to the terms of 15B6. So what 15D1 is simply making explicit, what it does is simply make explicit what would otherwise be implicit in 15B6. And 15B6 is, if you like, the main provision. And I would just ask you to note in passing that 15D1 also applies in connection with 15C6, which is the equivalent provision in relation to employment. And that's why I drew the analogy with the Semengo-Turner case decided by this court, which is in tab 9 of the court authorities. Fifth feature is a right to argue that certain terms in a consumer contract are not binding as being unfair under sections 60 to 67 of the CRA and part 1 of schedule 2 of the CRA. Now, so far as online auction contracts are concerned, we've included in case you're interested in it, an article which discusses terms other than arbitration jurisdiction agreements, which are commonly found in online auctions, which may be subject to these terms of the CRA. That's Supplemental Authorities, tab 14. But for present purposes, the most important aspect, of course, is paragraph 20 of part 1 of Schedule 2, which is on page 33 of tab 1b, which is the equivalent of what used to be in the old the old regulations Q. So Q in some of the authorities is now paragraph 20 in part 1 of Schedule 2 of the CRA. Sixth feature is that by virtue of Section 89 of the Arbitration Act, 1996, as amended, that right to challenge for unfairness under the CRA expressly extends to arbitration agreements. And I submit that that extension applies to both domestic arbitration agreements and agreements for arbitration in a foreign seat. And that's sections 89 to 91 in tab 1A of the authorities bundle. Now, as you no doubt will have seen, in a case where less than £5,000 is in dispute, an arbitration agreement is always void, and that's section 91.1 on page 22 in the bundle. In other cases, the fairness requirement of section 62 of the CRA applies, and the agreement is on what the CMA call the grey list of potentially unfair terms, including paragraph 20 at part 1 of Schedule 2, which is page 33 of the bundle. And we have in the bundle also the CMA's guidance on unfair contract terms, which is in the Supplemental Authorities bundle at tab 15, where they use the phrase grey list in relation to part 1 of Schedule 2, and it considers paragraph 20 on page 254 and following, and you might consider in particular that paragraph 5.29.3 on page 255 is relevant. Seventh feature is there is a statutory right to have the English court determine the question of fairness under section 71.2 of the CRA. That's page 30 in tab 1B, the core bundle.
Provided it has a close connection with it. Is that right?
Not in that provision. That's section 74.
I'm so sorry.
Yeah.
I'm so sorry. That's the,
No,
that's the governing law. Yes.
Yeah.
My mistake.
Yeah. The only proviso is it is qualified to a limited extent by section 71.3, which I'll come back to, which basically says provided it's got the materials before it. But that doesn't mean in my submission, I'll come back to it, but it doesn't mean you can wash your hands and say, well, we haven't got enough evidence today to decide it. The public policy is clearly that the court at the consumer's place of domicile should decide the point. Eighthly, now coming to choice of law, a right to have any express choice of law in the consumer contract which would disapply the CRA protection, which is imposed by sections 89 to 91 in respect of an arbitration agreement, ignored by the English court. And that is section 89.3 of the Arbitration Act, 1996, which is in tab 1A, page 19. There is also, not in the arbitration field, but separately, section 74 of the CRA, which I think is what your Lordship had in mind, which is dependent upon the contract having a close connection with the UK. But that doesn't apply, or there is a stricter test under the Arbitration Act, section 89.3. So there are two parallel things there, and one doesn't cut down the other. And then finally, ninth feature, a right under the Rome I regulation to have the law governing a consumer contract to be that of the consumer's habitual place of residence, that's Article 6.1, and to argue that any choice of law which lessens the consumer protection, which would have been available under the residence law, is ineffective. That is Article 6.2 of the Rome 1 regulation in Core 1G at pages 67 to 68. And we've also included for the discussion in Dicey of that, such as tab 23 of the Core Authorities bundle. So those are the nine features that are of relevance here. And in short, a consumer domiciled or resident in the UK generally has a right to have a court in the part of the UK where he or she is domiciled determine disputes arising under a consumer contract, including issues concerning the validity of the dispute resolution clause and the choice of law clause. Now, this is the point that I think is the most critical one, that although the learned judge referred to didn't really let it imbue her decision, in the English court, all of these provisions are mandatory in nature. That is to say that they apply by reason of the legislation in question and cannot be excluded by contractual agreement or in any other way. And the court, the English court, when an issue comes before it in raising these issues, it must apply and give effect to those provisions. It has no choice. Now, my Lord Justice Popplewell may remember a case called the Hollandia. I mean, it's nothing to do with consumers, but it illustrates the point. The Hollandia was the case about the COGSA package limitation, which would apply from a shipment at a UK port. And the House of Lords decided that a jurisdiction clause in the Bill of Lading, which would take the dispute to a case where a lower package limitation applied, was to be struck down because it was contrary to the mandatory effect of COGSA, which had to apply to bills of lading for shipments from UK court. Hollandia, sometimes called the Malvican. But it illustrates the point that when something is mandatory, the English court cannot allow any issue to be decided in a way which is contrary to the mandatory rights. I mean, they're completely different contexts.
But obviously, it goes without saying that the first three of your headings about Section 15B, and you saying it's mandatory, presupposes that it's applicable in the first place.
Absolutely.
Which is the question. I mean, that is one of the
Absolutely. I'm not shirking that point. I'm coming back to it, but I just wanted to give the general setting of what generally a consumer, if the person is a consumer and they qualify, what the benefits they have by virtue of what essentially is EU regulation, which is now part of English law. But I entirely agree. Arbitration exception is a critical point in relation to jurisdiction. I'm coming back to that.
Yeah.
But and the reason why these rules are mandatory is that, on the whole, consumer contracts are adhesion contracts in which the consumer has no opportunity at all to change the terms. The only thing the consumer can do is say, I won't deal with you if they don't like the terms, if they've even read them. And it's for that reason that the EU, over a long period, and then the UK, when it was in the EU and now continued post-Brexit, have decided, Parliament has decided, that these protections should have special force and should be incapable of exclusion by contract. But the point in this case is, and I'm not shirking the arbitration exception point, I'm coming back to it, but assuming I win on that point, the point in this case is that these mandatory, the mandatory aspect of English law only applies in the English court. In any other forum, these are not mandatory laws. And I know from cases I've done that sometimes in England, for example, we would give effect to, let's say, Russian mandatory laws in an English court if our conflict of laws rules say that the mandatory laws of another place should be applied in the circumstances of that particular case. But in this instance, as you've seen from the choice of law clause, clause 16, it has expressly excluded all, in capitals, the conflict of laws rules, and is expressly provided that New York law shall govern in this arbitration as if the contract was wholly made and performed in New York, without reference to any conflict of laws rules. So, just looking at it, there doesn't seem to be any prospect that in the New York arbitration that the English law would be applied, but even if it is applied, it's certainly not going to be applied as mandatory as it is in the current case. And so, but if this claim is determined in this jurisdiction, the consumer is entitled, subject to the arbitration exception point, to rely on the mandatory statutory protections that I've outlined. So I now come to that question. Does the arbitration exception apply? Or alternatively, if the judge is right to apply the better view of the argument test, is it the better view of the argument that the arbitration exception doesn't apply? I certainly submit that this court can decide clearly that the arbitration exception doesn't apply in this case, and I'll explain why in a moment. But the learned judge seemed to think that this was an issue on which the better view of the argument test might apply, and if that is the right approach, then I certainly submit a fortiori have the better view of the argument. The reason, of course, that this issue arises is because of the wording of section 15A2, which provides that the consumer and employee jurisdiction provisions in 15B2 and C apply only if the subject matter of the proceedings and the nature of the proceedings are within the scope of the regulation as determined by Article 1 of the regulation. And Article 1 of the regulation includes in paragraph 2, as one of its subparagraphs of paragraph 2 of Article 1, the arbitration exception. And the learned judge's conclusions on this aspect run from paragraphs 55 to 61, and her final conclusion is at paragraph 61, that the claimant's claim for a declaration that the arbitration clause was not binding was within the scope of the arbitration exception, and the claimant failed to establish the better of the argument on satisfying the jurisdictional gateway relied upon in invoking the English court's jurisdiction.
Mrs. Anning, apologies for my Apple Watch interrupting you. I'm afraid it's new and I don't really know how to work it.
Well, I
bury it
have
somewhere
one,
so
but
as not
someone
to
close
distract
to
you
me has
further.
one, and I can say that she doesn't have much control over what it does. And she probably had it longer than you. Now, my lord, in the case below, the parties were agreed that the correct test to apply was the better view of the argument test, and the judge did indeed purport to apply that test, and that's paragraphs 41 to 43 and paragraph 61. But in my respectful submission, nothing need necessarily turn on this, because we are correct, even if one applies a much stricter test, that this case is not within the arbitration exception. Now, the modern, I submit that the way one can see the law quite quickly in this area, and that the modern recent and authoritative court decision on which the test is discussed and applied is the London steamship case at tab 14 of the Joint Core Authorities, in which I think Lord Justice Popplewell sat. And that was, I think it was a combined judgment of the court, but I may be wrong. Yes, it seems to be. that, as I'm sure Justice Popplewell will recall, was an extremely complicated case arising out of the sinking of a tanker about 25 years ago in the Bay of Biscay. And there were 3 sets of claims, as one looks at page 360 and paragraph 4, that were being discussed in this particular instance. The arbitration claims, which are defined and discussed in paragraph 4.1, the award claims being discussed in paragraph 4.2, and the judgment claims, which were discussed and defined in paragraph 4.3. And if one then turns to paragraph 9, and also there were very complicated issues of state immunity as well. If one turns to paragraph 9, it refers to the judgment of Mr. Justice Butcher, holding that there was no state immunity in respect to the award or the judgment claims. And he held that the award claims fell within the arbitration exception. But then he held that the judgment claims were not within the arbitration exception. The arbitration regime applied, and in that particular instance, it meant that the English court did not have jurisdiction. And so that's paragraph 9. And the place in which the exception was discussed, and in my view this is authoritative, is page 379, paragraph 71 to 380. So page 380, paragraph 74. And the court says the test for whether proceedings fall within this exception are well established, first considered in the Atlantic Emperor. I won't read all of this. And then it refers to the detailed analysis by Mr. Justice Aikins in the Ivan Zugabansky. And that analysis was then approved by this court through transport case. Now, just giving you the references, Atlantic Emperor is tab 8 of the Joint Supplemental Authorities Bundle. Ivan Zugabansky is tab 5 of the Joint Core Authorities, and through transport is tab 7 of the Joint Core Authorities. And then the court says it is sufficient, this is paragraph 72 over the page, it's sufficient to cite what was said by Lord Justice Clark, giving the judgment of the court, also included Lord Wolfe and Lord Justice Ricks. In the result, Mr. Justice Aikins, in our opinion correctly, held that the question in each case is whether the or a principal focus of the proceedings is arbitration. That test seems to be consistent not only with the Atlantic Emperor, but also with the first instance decisions to which he referred, and we agree with him that the reasoning in those cases is to be preferred to that in the Heidelberg. Another way of putting the same point there is to ask the question posed by Mr. Justice Ricks in the Qingdao Ocean shipping case, namely whether the essential subject matter of the claim concerns arbitration. We do not think that is any different from the test which seemed to Mr. Justice Clark to be correct in Union de Remorquage, namely whether the relief sought in the action can be said to be ancillary to, or perhaps an integral part of, the arbitration process. And then they said we should also refer to the decision of the CJEU and West Tankers, referring to the claim in England for an anti-suit injunction. And then, I won't read all of that, but the last 4 lines, it says the judgment in Van Uden stated that arbitration is the subject matter of proceedings where they serve to protect the right to determine the dispute by arbitration. So and then in paragraph 74, the court says, accordingly, the question is whether the principal focus of proceedings is arbitration. The essential subject matter of the claim concerns arbitration, or the relief sought can be said to be ancillary to the arbitration process, these being alternative ways of expressing the same idea. So, if I can now make some submissions on that. There seem to be four phrases used here, but although they're intended to express the same idea. I know they've only mentioned three there, but there's the principal focus of the proceedings, the essential subject matter of the claim, whether the relief sought can be said to be ancillary to or perhaps an integral part of the arbitration process, and then finally, in paragraph 73, the last bit I cited, whether the subject matter of the proceedings serves to protect the right to determine the dispute by arbitration. And it is said that these are all alternative ways of expressing the same idea. And in my respectful submission, that it provides the answer in this case to the application of the arbitration exception, because the claim in the present proceedings does not satisfy any of these tests, or at least that is the better view of the argument, if the better view of the argument approach has to be applied. The reasons are as follows. Firstly, the essential subject matter of the proceedings is a consumer contract. Secondly, looking at the claimant's claim, the subject matter of the claim is to assert and vindicate his statutory rights qua consumer in relation to that consumer contract. The claimant is seeking to utilize and enforce his statutory rights. The principal focus of all the claims in this action is the assertion and utilization and vindication of the claimant's statutory rights as a consumer in the only forum in which those rights have the mandatory force of law. The claimant says that both Clause 16 and Clause 17 are contrary to UK consumer protection law. By these English proceedings, the claimant is not trying to enforce arbitration, or to enforce an arbitration award, or to protect his right to determine the dispute by arbitration. Claimant is instead relying on his statutory consumer protection rights and seeking to rely on that consumer protection in the only courts in the world which will accord mandatory legal force to such consumer protection.
Are you at some point going to deal with Mr. Justice Coleman's case, A and B?
I am, yeah. And I was fortunate or unfortunate enough to be in that case, and so I'm definitely going to deal with it. But
Your distinction is going to be, I expect, that was not a case in which consumer rights were relied upon to attempt to strike down or invalidate the arbitration provision.
Mr. Justice Coleman, you may have seen from paragraph 1.
I mean, was he right or wrong is the first question.
Well, if necessary, I would say he was wrong. And I was the winning party in that case. But I would say he was wrong if necessary, but I think it's distinguishable. And I will so submit in a moment.
Yep.
But I'm definitely going to deal with that. But that, I think, is the only case that, and it's only a first instance decision, that aspect didn't go to the Court of Appeal. The injunction aspect did. And in fact, one knows the names of the parties, because the strange thing is that his decision was anonymised, but the earlier decision of the Court of Appeal was not. So anyway, that is the only case that my learned friend is able to rely on the arbitration exception. And it's a first instance decision of very special and unique facts. So I will come back to it. But just to summarise, we say that where the consumer, the subject matter of the claim of the consumer, is his legal rights qua consumer, which he is seeking to assert in the only court in the world where those have mandatory recognition, if there is jurisdiction, of course, that the subject matter or the principal focus of the claim is consumer protection and the assertion of the consumer protection rights.
Consumer protection from what?
from an arbitration agreement in this instance. But on that, and I'm going to show you what was said in the West Tankers case about deciding an incidental issue, which is outside, if you like, the scope of the principal subject matter of the claim. Because what the Advocate General said in West Tankers, and what then the court adopted in West Tankers, is bang on point and supports me on that point.
Right.
So
I just want to be clear what your submission is on these points. And the consumer protection you're seeking to vindicate is a consumer protection from an unfair arbitration agreement. And is it also right that the statutory rights as a consumer which he is seeking to vindicate are statutory rights not to be subjected to an unfair arbitration? If not, what are the statutory rights which he's seeking to vindicate?
They are the rights I've already been through.
But is that a fair characterisation of them?
Well, and of course,
it's not all rights as a consumer. It's a claim for a declaration as to the invalidity of this arbitration agreement.
Yes, of course.
So is it fair to characterise that statutory rights as a consumer, which he's seeking to have vindicated in the arbitration claim, as a statutory right not to be subjected to an unfair arbitration?
Well, in my respectful submission, one looks at the subject matter of the claim and then the substance of the claim. And when we come to through transport, I'll show you what Justice Clark said about that. But it's the claim that one looks at, and the claim, and I will take you briefly to the pleadings, because they're not very long. I'll take you briefly to the pleadings to see what the nature of the claim is. But yes, the claim is to assert consumer protection rights in relation to unfair clauses which deprive you of the right to sue and be sued in your place of domicile. And it so happens in this instance that's an arbitration clause, and the consequence of a successful vindication of those rights will be a declaration that the arbitration agreement is void or not binding. But the rights that are being relied upon are the rights to sue and be sued in your place of domicile, and the consumer protection rights, which provide that if those rights are to be taken away from you, they must comply with section 15b6 of the Civil Jurisdiction and Judgments Act. And in parallel, they must comply with the fairness provisions of the Consumer Rights Act, section 62, which are made expressly applicable to an arbitration agreement by section 89 of the Arbitration Act, and in which part 1 of schedule 2 expressly includes, in paragraph 20, any agreement which deprives you of your right of access to the English court.
See, I think what's said against you is that the essential subject matter of your claim is not a consumer contract, as you, I think, started by saying, if I've written it down correctly. It said it's actually two specific clauses in the contract which relate to arbitration. And the subject matter isn't consumer rights, I think is said against you. That's just the tool you want to apply to invalidate those two provisions.
No, I can see that. That can be said. But ultimately, the court's got to make a decision on who's right. And I'm not denying that's the argument against me. But in my respectful submission, it's a far stronger argument to say that this case is not about arbitration. It's about consumer protection. And that's ultimately what it comes down to. And
does it come to this, Mr. Dillon? You say your client has a consumer right, lots of consumer rights maybe. One of them is a consumer right about arbitration clauses.
Well, not specifically. Yes, specifically arbitration clauses, but also under the CJJA against any agreement, 15b6, that takes away his right to sue and be sued under 15b2 and 3 in his place of domicile.
But he's not asking for any general relief in relation to that. He's asking specifically for this court to decide that this arbitration agreement is unfair. It's that consumer right he's seeking to vindicate.
unfairness comes in under the Consumer Rights Act. Under 15b(6) of the Civil Jurisdiction Judgments Act, there's no test of fairness, in fact. It's just, is it post-dispute or not? Does it take away your rights to sue and be sued in your place of domicile?
I mean,
we say it does.
To come back to a point that my Lord
Yeah.
Justice Popplewell put to you quite early on in the piece.
Yes.
If you were seeking a negative declaration, a declaration of no liability under this contract, it might be said that that is at least closer to making the subject matter of the proceedings a consumer contract than the actual relief you are seeking in this claim, which is targeted to two specific provisions that solely relate to arbitration.
I can see that distinction could be made, but it doesn't really focus on the substance. And I do want to show you what Lord Justice Clark said in a moment, and I do want to show you what's in through transport. But I take these points. I mean, I'm not denying that's my learned friend's argument, but we say it's wrong. I mean, and the English court should want to protect consumer rights in this context, and should not want to send any consumer off to a foreign arbitration to argue that English law applies in the face of a choice of law clause which says it doesn't apply. And the public policy is overridingly in favour of this court taking jurisdiction in order to give effect to the mandatory consumer protection. So I understand the argument on the other side, but I say that the court has to choose. Ultimately, is this a case which doesn't fall within the exception because it's the essential subject matter is a consumer trying to assert part of his package of consumer protection rights? And if it is, and then the court has jurisdiction, and it's hardly surprising that this is the law throughout the whole of the EU, which we only recently left, that a consumer has the right to sue and be sued in his place of domicile, just as an employee does. And I mean, if this is right, this argument, it would mean that employees could be deprived of their right to sue and be sued in their place of domicile by the employer putting an arbitration clause in the contract.
Well, it may depend on what you mean by the right to sue and be sued. If you're talking about the right to sue and be sued in relation to determining substantive rights and liabilities, then the regulation does that. We're not into the arbitration exception at all. The reason we're having this debate at all is that you're not seeking to vindicate your right to sue and be sued in relation to substantive liabilities. You're seeking to sue in relation to a really quite limited claim, namely the unenforceability, i.e. a jurisdiction question. Is that fair?
Yes, but I mean, well, I don't know. It's fair. The court has got to. It's almost an a priori thing here. You just got to say, what is this case about? Is it about consumer protection or not? Or do we treat it just like a ship owner or some other commercial party who's entered into an arbitration agreement, send them off to arbitration? And my respectful submission, the public policy is overwhelming in treating this as a case about consumer protection.
Well, I understand why you say that in general terms in the result, but
yeah.
Speaking entirely for myself, I want to try and disentangle. On the one hand, the policy considerations that you say apply to the application of the regulation and Section 15D as a gateway to jurisdiction, and the application of these principles if Section 9 comes to be applied. So, putting it crudely, if you're right about Section 9, and under Section 9, what the judge should have done, and what the court should always do, is decide these questions for itself, then do your points about the gateway disappear, really? Your policy points?
No, I don't accept that. But let me think about it a bit more. I mean, I don't want to get too I do see these points, but this is ultimately what the court has to decide, and to decide it on a fine technical distinction would be wrong in my respective submission.
Can I try and put in my terms what I think you're submitting on the point of principle? As I understand it, the point you make sounds like the point you're making is that you say that your client has certain consumer rights. One of those consumer rights relates to arbitration clauses. Indeed, expressly so. If you look in the relevant bits of the consumer rights you're talking about, they relate expressly to arbitration clauses.
Yeah.
You say your client is seeking to vindicate those consumer rights which relate to arbitration clauses as a matter of jurisdiction.
Yes.
And yet, because they are the consumer rights that relate to arbitration clauses, you're bumping up against a problem because they relate to arbitration clauses, which means that they're not, the court apparently doesn't have jurisdiction to do it, says the opponent and says the judge.
Yes.
And that doesn't make sense, because if your consumer rights relate to arbitration clauses, your consumer rights ought to be vindicated in this court.
Yes.
But that's I think what you're...
That is what I'm saying. And I'm sorry, perhaps I haven't put it as clearly, but that is one way of putting it. And maybe I would go slightly out of the order I was intending to do, but I'll take you to the way that it was analysed in the through tankers case.
Just before you do that, just following on from Oliver's point, can you just explain? You mentioned the parallel to employment. Can you just give us the parallel that you say exists? I mean, I know employment is dealt with obviously in section 15A.
15B, 15C, 15C.
Well, sorry, it's dealt with in 15 big A, 1 little b.
And in 15C.
Yeah, and 15C. Yeah, but that's the way you get into it. But you say that here we've got a consumer who has a specific right, as a matter of consumer law, to have rendered invalid on grounds of unfairness an arbitration provision because it sends him off somewhere other than the court of the place where he's domiciled, broadly speaking. I've sort of probably mangled a little bit of the...
Well, I'm actually relying on two provisions. I'm relying on the Consumer Rights Act incorporated by Section 89.
Yep.
But quite apart from that, I'm relying on Section 15B6 and 15D1,
but just
which is not specifically related to arbitration at all.
All right. Okay. Well, what I wanted you to do is just before, for me anyway,
yes,
before you get to start looking at the cases we're about to look at, just can you paint the picture for the employee, which you say is potentially affected in the same way, so that when we're looking at how this plays out for consumers, how do you say it could or should play out for employees? Give me an example. Illustrate the sort of situation that you say might arise.
Well, one is the Semengo-Turner situation. That case, though it concerned a jurisdiction clause, in all other respects was the same argument, and the court held that the jurisdiction clause, that the employee had the right to sue and be sued in England, not in New York under the exclusive New York jurisdiction clause, and that right was so strong that he could get an injunction to prevent the proceedings in New York under the exclusive.
But is there an Employment Act overlay in the same way that there's the Consumer Rights Act overlay?
No.
With employees?
Well, I don't know if there's anything in the Employment Act, but it's in the Civil Jurisdiction and Judgments Act, and it was originally in the recast regulation. So, in fact, it was I think the non-recast regulation that was before the court in Semengo-Turner.
But an employee wouldn't be looking to vindicate a particular set of statutory rights applicable to him as an employee in the same way as you say the Consumer Rights Act.
No, I mean the employee has the same rights in 15C to sue and be sued in his place of domicile.
Right, but he doesn't.
And it has the same right under 15C6 to argue that any agreement which is not a post-dispute agreement, which takes him to some other place, is invalid, and that is then reinforced for employees as well as consumers by 15D1. So that's where those rights come from. Now, although they used to be in the regulation. And we say that my client has two arguments. One is that he shouldn't be forced to go to the United States because of 15b6 and 15d1, which is the same argument that would be available to employee. And secondly, that he has rights not to go there under the Consumer Rights Act, which are made expressly applicable by Section 89 of the Arbitration Act. So the twin arguments.
Right, but the employee would not have the second of those.
Not have that, and I don't know enough about employment law to know whether there's any equivalent provision about unfair terms in employment contracts, I'm afraid. But we could probably research it.
Well, I just have it in my mind, the sort of analogy you were trying to draw is the employee, let us say, of a US corporation working in the UK, who has in his employment contract a provision that says any dispute relating to this employment must be resolved by arbitration in New York. I mean, that's the sort of fact pattern you introduced, isn't it?
Yes, I did mention that. I mean, perhaps I should.
So I'm just I'm just trying to understand what bit of the argument we're about to embark upon has relevance to that, and I think you're saying it's that which appears under the Section 15 of the CJAA.
15C, yes.
But not the what I've called the Consumer Rights Act overlay.
Yeah, because under 15b6 and 15c6, any agreement, unless it qualifies with the three conditions in 15b6 and 15c6, that takes away the right to sue and be sued in the place of your domicile, is ineffective. And that is spelt out by 15d1, both for consumers and for employees. Okay. And that's where those rights come from in the case of employees that I'm referring to. So if I could take you to I was going to deal with A and B, so I'm perhaps going slightly out of order here. I think maybe it's better if I stick to my existing order, and I will answer these questions.
Don't let me drag you out of sequence, because that's
the danger is I'll miss something out if I turn over too many pages in one go. So what I was just going to say very quickly in relation to the cases that were referred to in paragraph 71 that we looked at in the Prestige numbers 3 and 4. That's the Atlantic Emperor, which is at tab 8 of the Joint Supplemental Bundle. That was a shipping case, a commercial case about an arbitration clause in bills of lading. Went to the ECJ. It was a case where the claim was to have the English court appoint an arbitrator. And that was the claim that was being asserted before the English court. Would you please appoint an arbitrator? And so that's why there was reference to the court being asked to play a role in the arbitration process. And the ECJ said that the proceedings before the English court were part of setting the arbitration proceedings in motion. So that was a claim, if you like, to enforce or make effective the arbitration agreement. And it was not, obviously, in a consumer context. The Ivan Zugabansky, the next one, is at tab 5 in the Joint Court. It's another shipping case, again involving bills of lading. It was again a claim to enforce an arbitration agreement by asking the English court to grant an anti-suit injunction against rival French proceedings. And that's the case in which Mr. Justice Aikins reviewed the authorities and said the test was the principal focus of the proceedings. It's hardly surprising that he said that, because that was a case where he was being asked to grant an anti-suit injunction to restrain the French proceedings on the basis that they were brought in breach of the London Arbitration Clause. Then there's the through transport case, which is tab 7 of the Joint Authorities Bundle. That was another case where the claimant's claim was for a declaration that the arbitration agreement was binding, and an anti-suit injunction against the proceedings was then sought for breach of the arbitration clause by bringing court proceedings in Finland. So again, it was a claim to enforce and protect the arbitration proceedings. And Mr. Justice Moore-Bick at first instance held that the exception applied, gave the declarations and granted an anti-suit injunction. The Court of Appeal agreed that the exception applied and that the court had jurisdiction, and continued one aspect of the declarations but refused the injunction for other reasons. And that was the case in which the court, at page 200 in the bundle, expressly agreed with Mr. Justice Aikins in relation to the test being the principal focus of the proceedings. And what I would like, if I can ask you just to turn up tab 7, is to highlight what Lord Justice Clark said, not just in that passage on page 200. And we've highlighted in red the relevant parts. The point that I was just referring to is paragraph 2, page 200, paragraph 47, where there was approval of Mr. Justice Aikins' approach about the principal focus, and that was what was quoted in paragraph 72 in the Prestige case that we looked at. But if you turn on, please, to the 2 pages further on, to page 202 in the bundle, paragraph 56. I just wanted to stress the very first sentence there. We agree with the judge that those principles involve a consideration of the substance of the claim being advanced. And I respectfully submit that both of those 2 points, those 2 features in that sentence are correct. One's looking at the claimant's claim, and one's looking at the substance of that claim. That is why we say that the substance of the claim being advanced by the claimant, even in relation to the arbitration agreement, is to assert and enforce his rights as a consumer to be protected from an agreement which is contrary to the Civil Jurisdiction Judgments Act or contrary to the fairness requirements in the Consumer Rights Act. And very briefly, I'm sure you've probably looked at the pleadings, but the pleadings in this case are in the Supplemental Appeal Bundle at tab 2. Very quickly, the particulars of claim are there. The first paragraphs 1 to 15 set out the background, and I won't dwell on that. And then the claims are set out from page 12 in the bundle, paragraph 16 and following. It says, paragraph 16 says, the claimant is and was at all material times in his dealings with the defendant acting as a consumer within the meaning of section 2.3 of the Consumer Rights and within the meaning of subsection 15E1 of the Civil Jurisdiction Judgments Act. So he's asserting he's a consumer and it's a consumer contract. And then he says part 2 of the Consumer Rights Act applies to the account and to the entirety of the claimant's contractual relationship because it has a close connection with the United Kingdom. He sets that out. He says in paragraph 18, the February 2020 terms, and insofar as they may be relevant, the April 21 terms are therefore assessable for fairness pursuant to section 62(4) of the Consumer Rights Act. And then turning to clause 17 specifically, either alone or in conjunction with clause 16, unfair terms are contrary to the requirement of good faith, cause a significant imbalance in the parties' rights and obligations to the detriment of the claimant, and is unfair. And then there are particulars of that, referring to paragraph 20 of part 1 of Schedule 1, and spelling out that it purports to restrict the consumer's rights to take legal action in a court in the United Kingdom, purports to require the consumer to submit to exclusive jurisdiction of an arbitration not covered by legal provisions, seat of which is in New York, deprive the right to be sue and be sued in the English court, a right which is provided to him by sections 15b(2), 3 and 6 of the 1982 Act, failing to ensure he was properly informed under the Consumer Rights Act, and I won't read all of this. So all of that's based on those being unfair terms under the legislation. Then the claim in relation to the clause 16, again contrary to good faith, causes a significant imbalance in the parties' rights and obligations. And the particulars are given of that. And then it says in 21, in the premises, the unfair terms are not binding on the claimant pursuant to subsection 62(1) of the Consumer Rights Act. The unfair terms are inconsistent with the claimant's rights under subsections 15b(2), 3 and 6 of the 1982 Act, and consequently ineffective and not binding. Claimant's right to sue and be sued in his home jurisdiction cannot be bargained away, save in the circumstances provided by subsection B6, and the unfair terms are inconsistent with 15b(2), 3 and 6, in that they were not entered into after the dispute had arisen, and therefore he seeks a declaration that the unfair terms are unfair and do not bind him. And then there's the separate point in relation to the Gaming Act. Now, we respectfully submit that if you apply the 3 or 4-pronged test that the Court of Appeal enunciated in the recent Prestige numbers 3 and 4 case, then and one focuses, as Lord Justice Clarke said in Through Transport, on the substance of the claim, the essential basis of these claims and the substance of these claims is the legislation to protect consumers against unfair terms in consumer contracts. And it just so happens that the particular term that is sought to be impugned is the one that takes away the rights to sue and to be sued in one's place of domicile. But that doesn't alter the characterization of the substance of the claim. The substance of the claim is the protection of consumer rights. And one can see that from the pleading, because everything that's pleaded is in view of either setting out the relevant consumer protection legislation or pleading facts as to why the relevant consumer protection legislation applies. There's nothing pleaded which is intrinsically arbitration. That is simply the consequence of invoking the rights. So the substance of the claim are those consumer protection pieces of legislation, and the facts that are relied upon as bringing the claim within the scope of that legislation. Now, it is true, as I say, that the consequence of the claim being successful is that a declaration will be given that the arbitration agreement is not binding and not effective.
Well, that is the relief that's sought, the relevant part of the relief that's sought.
Exactly.
It's not just a consequence of the argument.
That
is the claim.
That is the relief. That is the relief that's sought in the prayer.
Yeah.
Yes, exactly. And that is where I'd like to refer you to what was said in West Tankers, which we have in the joint core bundle at tab 18. Now, West Tankers was the famous case about anti-suit injunctions within the EU space, and we're not focusing exclusively on that for present purposes. But could I show you first of all what the Advocate General said on page 463 to page 464. Paragraph 54 in the Advocate General's opinion. The existence and applicability of the arbitration clause merely constitute a preliminary issue which the court seized must address when examining whether it has jurisdiction. Even if the view were taken that that issue fell within the ambit of arbitration, as a preliminary issue, it could not change the classification of the proceedings. The subject, I'm now at B, the subject matter of which falls within the scope of the regulation. And then going on at 55, incidentally, it is consistent with the New York Convention for a court which has jurisdiction over the subject matter of the proceedings to examine the preliminary issue of the existence and the scope of the arbitration clause itself. And then it refers to Article 2.3 of the New York Convention, and in particular subparagraph Roman 3, the end of that paragraph, the court seized does not find that the agreement is null and void, inoperative, or incapable of being performed. If the court does find that the arbitration agreement is null and void, inoperative, or incapable of being performed, it doesn't have to give effect to it. And then it says this, and this is very important, paragraph 56, every court seized is therefore entitled, under the New York Convention, before referring the parties to arbitration, to examine those three conditions. It cannot be inferred from the Convention that the entitlement is reserved solely to the arbitral body or the national courts at its seat. So the three conditions are the three matters listed in Article 2.3 of the New York Convention, which are set out in paragraph 55. So what the Advocate General is saying is, if it's a case that falls within the jurisdiction, because it's on a head of jurisdiction under the Convention, but it is said there's an agreement for arbitration, the court which is seized of that matter can and should decide whether the arbitration agreement is null and void, inoperative, or incapable of being performed. And this relates to the submission I'm coming on to in a moment. And then you can see how the court latches onto that.
Ismail, I'm not quite following what you get out of that. Is that not the Section 9 exercise?
No, this is a jurisdiction. This is on jurisdiction. And if because and that is clear.
I'm sorry, it's my fault. Paragraph 50. Every court seized, so that assumes it's got jurisdiction. It's therefore entitled under the Convention to examine the three conditions.
No, I don't know if it's. Seized doesn't just presuppose that it's decided it's got jurisdiction. It's just dealing with the matter, and it has to decide whether or not. And can I show you? If I show you the judgment, maybe this will make it clearer. Perhaps it won't. But at page 471, where this is then adopted in the judgment, at paragraph 26, in that regard, the court finds, as noted by the Advocate General in paragraphs 53 and 54 opinion, that if, because of the subject matter of the dispute, that is, the nature of the rights to be protected in proceedings, such as a claim for damages. So again, that is entirely in line, I would underline that. It's entirely in line with what Lord Justice Clark says. The nature of the rights to be protected in the proceedings. It's not, and then it goes on, such as a claim for damages, those proceedings come within the scope of the regulation, preliminary issue concerning the applicability of the arbitration agreement, in particular its validity, also comes within its scope of application. And then in 27, the court says, it follows that the objection of lack of jurisdiction raised by the claimant before the Tribunale de Siracusa on the basis of the existence of an arbitration agreement, including the question of the validity of that agreement, comes within the scope of the regulation. And that is therefore exclusively for that court to rule on that objection and on its own jurisdiction. So I think that answers your question, Justice Popplewell. That this is being said in a jurisdictional context. So, as I understand what's being said here by the Advocate General and then by the court, is you look at whether the nature of the rights to be protected in the proceedings fall within the scope of the convention. If it is then said that the court doesn't have jurisdiction over those rights because of an arbitration agreement, for example, the court can and should decide that at a jurisdictional stage, because otherwise you are depriving the person of jurisdiction, which they would otherwise have, on the basis merely of an allegation of arbitration. And that takes us back to the second sentence of paragraph 56 of the Advocate General's opinion, page 464. It cannot, and this is referring to the New York Convention, it cannot be inferred from the Convention that that entitlement, namely to decide whether the arbitration clause is valid or not, is reserved solely to the arbitral body or the national courts at its seat. In other words, when a court is faced with a claim with someone asserting jurisdiction under a package of rights or a set of rights which are within the scope of the regulation, the convention, and another person says, but that is subject to arbitration, the court has to decide that. In order to determine its jurisdiction. And that is, I think what has happened is that the regulation has now been amended to underline that point. So I don't think this was in the regulation at the time, but the recast regulation, which we have in Bundle 1E at page 46, underlines this point in recital number 12. I think is not the same as it was previously, at page 47, and recital 12 in the recast regulation.
Just give me a minute.
Page 47 in bundle, core authorities, tab 1E, says this regulation should not apply to arbitration. But nothing in this regulation should prevent the courts of a member state, when seized of an action in a matter in respect of which the parties have entered into an arbitration agreement, and then skip down, or from examining whether the arbitration agreement is null and void, inoperative or incapable of being performed in accordance with their national law. So nothing in the regulation, the recast regulation, is supposed to stop the court from making a determination as to whether or not the arbitration agreement is invalid. So, in my respectful submission, this underlines what I was saying earlier, that the court must look at the rights that are being asserted, particularly as described by the court in West Tankers, in the paragraph I took you to, and whether those fall within the scope of the regulation. And if those fall within the scope of the regulation, then if there's a question of arbitration, that then has to be decided as to whether or not there is an arbitration which, as it were, takes the case outside the regulation. And there is an example of the German court doing just this. It's the Zellner case that we referred to in our skeleton argument, which is in the bundle. So the Zellner case was before the recast regulation, and it was actually a case under the Brussels Convention. But it's not totally dissimilar to the present case. The Zellner case concerned a number of German nationals who entered into contracts for, I need to be reminded, but it's some sort of trading in futures and options or something like that, with a firm that was ultimately based in London, but through an agency in Germany. And that contract contained in its standard terms an arbitration clause for LCIA arbitration in London. The German court looked at it, and I'll show it to you in a moment. The German court looked at it and said, well, this arbitration agreement is contrary to our consumer protection law, or our mandatory law that applies in these situations. And therefore, we will assert jurisdiction because this contract was made through an agency in Germany, which is one of the other heads of the Brussels Convention. And they decided the point as to whether or not the arbitration agreement was binding, and en route to deciding the question of jurisdiction. So shall I show you that? That's in Zellner. It's at tab 3 in the core authorities bundle. I mean, it was actually part of some quite widespread litigation at the time, and there were some English cases. There was quite a famous case called Bamberger, which is in tab 2, and another case which came out of the Zellner case, which also was an English decision, which is at tab 4. But I just want to show you the German decision. At 117, if you found that, my lord, jurisdiction, EC, Judgments, Convention, Brussels, 1968, branch, agency or other establishment. And you see the first part of the headnote on 117 is to deal with Article 5.5 of the Brussels Convention, and the corporate entity had established itself in Germany. And then the second part of the headnote, jurisdiction, validity of arbitration clause, consumer protection. Although under Section 27 of the Civil Code, Implementation Act, a choice of English law to govern an arbitration agreement is permissible in principle, Section 29 of that Act restricts the free choice of law in consumer contracts, such that a customer must not be deprived of the consumer protection available to him in the state in which he has his normal residence, Germany. And the principle of more favourable legal protection applies. And they held that the arbitration agreement was invalid. And then if you go down to the last 8 lines of the headnote on page 118, the German court concluded that it had jurisdiction over the third defendant under the EC Judgments Convention on the basis of Article 5.5, since the first defendant was in practice operating as an establishment of the third defendant. An objection to the jurisdiction of the German courts based on an arbitration clause in the agreement between the plaintiff and the third defendant was rejected on the grounds the arbitration clause was invalid. So that's an early example of the German court doing exactly what I'm inviting the English court to do in relation to a similar sort of transaction in some ways. And the parts that are relevant in the judgment have been sidelined on pages 1, 2, 3, and 1, 2, 4, and 1, 2, 5. And I wasn't going to read them all out. That shows you the reasoning in more detail and is set out in the head note. So, in my respectful submission, there's nothing odd or unusual about an English court or another court in the EU deciding that they're going to decide whether the consumer protection legislation invalidates an arbitration agreement en route to deciding whether they have jurisdiction. And that's exactly what the German court did in the Zellner case. Even though at that stage the recital in Article 12 was not didn't go as far as it now does in light of the decision in West Tankers. Now, coming back to Lord Justice Snowden's question about the decision of Mr. Justice Coleman in A and B, we have that in tab 8 of the Joint Authorities bundle, but I wasn't going to take you through it line by line. I wanted to say the following things about that case. First of all, it was not a case of consumer protection against arbitration or against any term in the contract. In fact, if you read the facts of the case, the very opposite was the situation. That was a case in which the arbitration agreement was very much made at arm's length. It was specifically negotiated and agreed post-dispute, and the arbitration agreement specifically recited that both parties, who were brothers, had received legal advice before entering into the arbitration agreement, which they agreed to arbitrate before a well-known English solicitor who was known to both of them in Geneva. It was such an odd case that if you look at paragraph 1 of his judgment on page 214 in the joint call, you'll see that Mr. Justice Coleman said, and I'm quoting, "It was without doubt the most unusual arbitration dispute that I've ever encountered, either professionally or in the law reports." And coming from him, that was quite a statement. But what had happened in that case is that the parties had entered into this arbitration agreement with legal advice post-dispute, and the arbitration had started in August 2004. And that's paragraph 37 on page 217. They had then been arbitrating, engaging with the arbitrator for around a year, when one of the two brothers was unhappy with the way that the arbitration was progressing. And he sought, at that point, a year later, to rescind the arbitration agreement on the basis of alleged error, deception, fraudulent misrepresentation, and duress. That's paragraph 58 on page 219. And so at that point, in August 2005, the arbitration having got underway in August 2004, he commenced the London court proceedings, that's paragraph 59 on page 200, claiming that the arbitration agreement was void or mistake or had been rescinded, and that the orders that the arbitrator had made were not binding upon him, and that the arbitrator should be injuncted from proceeding. Now, it is true that Mr. Justice Coleman did hold that the entire proceedings fell outside the regulation because the arbitration exception applied, and he granted also a stay of the English proceedings under his inherent jurisdiction. But it was a first instance decision, it was made not in a consumer or any sort of mandatory law context, and it was an utterly remarkable and unusual case where what was the substance of what was going on is that a dissatisfied litigant before the arbitrator was seeking, long time after the arbitration agreement had been entered into post-dispute, and after he'd been participating in the arbitration, to claim that the arbitration agreement was now void, even though he'd entered into it with legal advice, and should be rescinded. So it was not a case of an initial objection to the arbitration agreement, because the arbitration agreement had actually been performed for some time and a number of orders had been made by the arbitrator. And so I say it is distinguishable because essentially that case was a case about dissatisfaction with the way that the arbitration was progressing, but it was dressed up in the English court as something different. It was really an attack on the way that the arbitrator had been handling the arbitration in Switzerland. And it was only launched when the proceedings went against the brother. Now, it's easy to see why those complaints should have been taken either to the arbitrator himself or to the court in Switzerland, which has supervisory jurisdiction over the arbitration. So I say it's a remarkable case, distinguishable. If that is not right, or Justice Snowden, then I say that if the case is an authority against me, that a claim to impugn an arbitration agreement is within the arbitration exception, I say that is wrong. And in any event, it's only first instance, and it's.
You say that's wrong in a commercial context. Leave aside any argument in relation to consumer rights.
Yes, I do, if necessary.
That certainly strikes me as a little odd. If an application to uphold an arbitration agreement as valid does engage the exception, it would be slightly surprising if the
Sorry, I misunderstood your question. I agree. No, I'm not. I don't say it in the commercial context. I say it in the context of this case, because the substance of the rights here, the focus, I don't want to go back over the test, but the test in this case is that the rights that are being relied upon are not rights to enforce an arbitration.
No, I understand that.
And mandatory consumer protection rights.
That would be a ground for saying this is distinguishable because it's not dealing with consumer rights.
Yeah, exactly.
What I wasn't quite following was on what basis you say it was wrongly decided.
Well,
Indeed,
well, perhaps let me just say this. It's either distinguishable or it shouldn't be followed. Because it's only first instance, and it certainly shouldn't be followed in a case such as the present one, where the rights relied upon are mandatory consumer protection rights, which are only mandatory in the English court, and therefore it's only the English court that can decide whether that protection, that mandatory protection, has an effect on the contract, and in particular on the arbitration agreement.
So if I wrote down that your argument is that it's distinguishable on two bases: first, the extraordinary facts, and secondly, that it wasn't concerned with consumer rights in the way we are.
Yeah.
Would that be a fair?
Yes, and in any event, it's not binding on this court. And also, I think also the other thing is that that was in 2006. So, let's see, was it before through transport? Maybe, just on the timing, it was certainly, we'd have to look at exactly when in the sequence of authorities that case was decided, my lord. But it may have been before through transport. It's certainly before your recent decision in Prestige numbers 3 and 4. Obviously. It was decided. It's tab 8. It's in 2000, yes. It's in 2006. So we can see where it's located in in the authorities. But certainly, let's have a look at through transport. Through transport was 2004, in fact. So, yeah, so that would have been available to the judge at that time.
Thank you. Can I take you back to through transport just for a moment?
Yeah.
It's convenient because, in a sense, keep your finger in tab 8.
Yes.
Since we're there, it's the previous tab. You took us to the start of paragraph 56 of page 202.
Yeah.
And you emphasised that what was required was the consideration of the substance of the claim. Yep.
Yes.
Now, putting aside how the previous paragraphs dealt with that, what Lord Justice Clarke then went on to do was to sort of say there's a couple of statements of the court in other cases that bear this out. And one of them you'll see just a little bit further down is Lord Justice Old in Macmillan, where he says it follows from what I've said that the proper approach is to look beyond the formulation of the claim and to identify, according to the Lex Fori, the true issue or issues thrown out by the claim and defence.
Yes.
And then a bit further down at paragraph 57, at the bottom of that column, we agree with the judge those are helpful statements because they recognise that the court is concerned to identify the true issues, or as Lord Justice Old has put it, the question at issue.
Yes.
Then going back to A and B, I mean, the question at issue could be said, could it not, to be that which, as Justice Coleman identified at the start of paragraph 61, namely whether the arbitration agreement is void or whether it's been validly avoided. I mean, the myriad of grounds upon which the claimant might say that it's been void or avoided, whether it's misrepresentation, duress, undue influence, whatever.
Yeah.
The issue is the arbitration agreement void or avoided, has been avoided? Does it go back to the point I made to you earlier that you may say that this is a consumer case, but the issue in your claim is, are the arbitration clauses enforceable or not, valid or invalid? It's just that one of the bases upon which you say that is so is consumer legislation. What's the difference between you relying on consumer legislation to invalidate the clause and the claimant in A and B relying upon it's a myriad of stuff: misrepresentation, duress, undue influence, error, deception, blah blah blah, to set aside the arbitration clause? The issue is whether the arbitration clause is valid or not. That's I see the.
Yes, I see that, and grateful for you drawing attention to those passages in the left-hand column on page 202,
Yeah.
because in my respectful position, they reinforce what I've been saying, which is it is the issues that are relevant. It's the rights which we get from West Tankers that are relied upon, and the issues that arise out of the assertion of those rights. Now, I'm coming back to your question.
Yeah.
But the issues that arise in our pleading are the questions of whether or not those pieces of legislation apply on the facts of the present case, in view of the pleading, the matters that are pleaded in the paragraphs I took you to in the pleadings. And ultimately, it's a very simple, it's a very short point. Does one say that the focus of the claim, the rights that are being asserted, are those statutory rights under the CRA and the CJJA? We say that one does, and that the relief that is claimed is simply a consequence, if it is successful, of succeeding in asserting those rights.
But why didn't Mr. Justice Coleman then say, when he was asked, oh no, the issues therefore are, has there been fraud, has there been deception, has there been misrepresentation, has there been undue influence?
Well, those are all contractual issues related to the arbitration clause. Because in English law, an arbitration clause, somewhat unusually in the world, is treated as just a term of a contract subject to normal contractual analysis. So they are just, as it were, pure common law, or possibly equitable, issues intrinsic to the nature of it as an arbitration agreement. But the difference in our case is that we are relying on a body of statute law, as my Lord Justice Birss said, which creates a set of protections against unfair terms, one of which happens to be a term which deprives you of your right to sue and be sued in the English courts by requiring you to go to arbitration. But that is, as far as I can tell, and coming back to your original question to me earlier this morning, this is the only outlier. This is the only case in which has decided the question of the application of the arbitration exception applies to a claim, as it were, to invalidate arbitration. In every other case, the test is what are the nature of the rights being asserted? What is the focus of the claim? Is it something that is enforcing the arbitration agreement or ancillary to enforcing the arbitration agreement? All those different phrases that were used in the Prestige numbers 3 and 4 that I showed you in paragraphs 71 to 74 of the Prestige 3 and 4. So that there's no other case like this, as we have found, on the arbitration exception. And that's why, and certainly so far as the current case is concerned, we say that the rights being asserted are the consumer rights, and we rely on those passages in the West Tankers case, which distinguishes between the rights that are being asserted for the purpose of jurisdiction and the fact that may lead to a ruling that, or there may be a ruling that an arbitration agreement is invalid. And that the fact that there may be a ruling that an arbitration agreement is invalid does not take the matter, the court said in West Tankers, does not take the matter outside the regulation.
Can I ask you about the Schlosser Report, which I think I can do conveniently by going to the Ivan Zagubansky behind tab 5. And at page 159 of our bundle, page 117 of the report, we have Mr. Justice Aiken's at paragraph 70 summarising the Advocate General's opinion in the Atlantic.
I'm sorry, I misheard the page number, mine.
Sorry, 159 of the bundle,
159.
117 of the report.
Yes.
Paragraph 70.
Yep.
And he's summarising the principles that the Advocate General in the Atlantic Emperor had identified, which he later says are all the reasons which he would adopt for saying that the claim in that case was caught by the exclusion. But one can pick it up, if I may, at subparagraph 5, where the judge records Advocate Damon as saying, in any event, a dispute as to the existence of an arbitration agreement falls outside the scope of the convention. This opinion is reinforced by the view at paragraph 64 of Professor Schlosser's report on the accession convention. We've got then quoted at footnote 32, which is why I've taken you
here to see what was said in the Schlosser Report. A judgment determining whether an arbitration agreement is valid or not, or because it's invalid ordering the parties not to continue arbitration proceedings, is not covered by the 1968 Convention. Now you're seeking, aren't you, in this case, a judgment determining whether an arbitration agreement is valid?
Yes, and I'd say that the law has moved on since then. I mean, the law focuses now on the nature of the rights being asserted, and I would take you back to paragraph 3 there. What is the principal issue before the English court? Well, the principal issue before the English court is whether these terms are unfair or invalidated by the Civil Jurisdiction and Judgments Act. That's the issue. If we succeed on that issue, it is true that the arbitration agreement is then, as a consequence of succeeding on that issue, it is held to be invalid and the declaration is granted. But the nature of the rights is those rights under the legislation. That's the subject matter of the claim, and the principal issues are the issues that arise out of
Hang on,
pleading.
Just to cut you there.
Paragraphs 16 to 23.
Aren't you misquoting section 15A2? I mean, that talks about the subject matter of the proceedings and the nature of the proceedings. Why are you talking about nature of rights?
Because that's what the Through Tankers Court of European Courts talked about in the passage I took you to. So we go back to that. So we've got Lord Justice Coleman talking about the substance of the claim in Through Tankers at paragraph 56. And then West Tankers, Joint Corp tab 18, which certainly does, just in terms of the chronology of these cases, certainly does come after Mr. Justice Coleman's decision. And it is referring in paragraph 26. And the third says, if because of the subject matter of the dispute, that is, the nature of the rights to be protected in proceedings.
Such as a claim for damages.
Such as a claim for damages, those proceedings come within the scope of the regulation. A preliminary issue concerning the applicability of an arbitration agreement, including in particular its invalidity, also come within its scope of application.
But that's drawing a distinction, isn't it, between, on the one hand, rights that are sought to be protected, i.e. substantive rights, the substantive rights in the dispute, and a preliminary issue as to whether those rights have to be determined in arbitration or elsewhere. The difficulty about applying that to our case is you say there aren't those two separate questions, they're the same question. The rights which are sought to be protected are the rights as to the scope of the arbitration agreement.
Well, I draw your attention to that. It draws a distinction between, first and foremost, it focuses, and I think I was answering my Lord's question about where did I get the formulation about the rights from. That's where I get the nature of the rights to be protected in the proceedings is equated with the subject matter of the dispute by in that sentence there. That's the first point, and the reason I referred to that.
Well, I understand that.
Yeah. So it's the nature of the rights.
But it may be an important distinction for us, because one of the themes of your argument is essentially the consumer right that's you're seeking to protect is the right to sue and be sued here as someone's domiciled here,
Yes.
reflected in the
That's right.
convention. But that raises in my mind a question of right to sue and be sued here for what? And it may be that the distinction is between the right to sue and be sued in relation to the substance of the rights and obligations about which there is a dispute. So here, for example, claim for damages. And what you say is the right that it applies to in this case, which is a right not to have to arbitrate, which is not necessarily a right of the same quality.
But by making
And
that the
that's-
claim, that is the substance. That is the thing that's being claimed here, and the rights that are
I'm so
being
sorry to interrupt. But that begs the question as to whether that is the same as the right to sue and be sued,
Yeah.
which is reflected in Article 18 of the regulation.
Yeah. And I come back to the same point, which is ultimately one has to break into this circle somewhere, and one just has to take a view. Is this a case which is a consumer protection case, or is it an arbitration case? I mean, when one knows that the exception, for example, is very broad. It just says arbitration. That's what it says. So, is this case arbitration, or am I right in saying that it's a case to enforce statutory mandatory rights under English law, which has the consequence that if we are right in asserting those rights and we win on the issues of fairness and construction of the statute, that the arbitration agreement, the relief then is awarded, that the arbitration agreement is not valid. That's the issue. And I don't think pure logic takes you to one correct answer or not. One simply has to take a view as to whether this is a case which is concerned, as I submit it is, with a consumer domiciled here who prima facie has a right to sue and be sued here, and either has a right that any other agreement must be post-dispute, that's section 15b(6), or has a right that any arbitration agreement has to be fair, and if it's unfair, it's not valid if it's for more than £5,000. It's for £5,000, it's automatically invalid, under £5,000. That whether it's right to say that asserting that protection that the law has given you, which is mandatory in this court, is the essential focus of the claim. We say it is, and therefore the arbitration exception doesn't apply. And that is, by far and away, as a matter of public policy, the best result to come to, because otherwise it would be quite unfortunate if it were possible to sidestep these consumer protection rights and also employee protection rights.
Unless you're right on ground 3, in which case all the protection comes in under section 9.
Well, that is a separate issue, but it's as a matter of jurisdiction. Let's put it this way. Just imagine what the choices were that were facing my client when the arbitration was commenced against him in New York. Let's assume my client had some advice and knew that he had these rights to sue and be sued in England as a matter of mandatory English law. How was he to assert that right and to establish that the arbitration agreement was invalid?
The answer may be, he brings a claim for a declaration of non-liability for the price. There's no jurisdictional problem with that. If he's met by a Section 9 application, he says to the court, as you say now, my statutory mandatory UK rights mean that the arbitration agreement is to be ignored. You can decide that now. And then he goes to New York with his judgment and says, there we are, it's raised judicata between us, that the arbitration agreement is unenforceable.
But that presupposes that Nifty participate in English proceedings and make a stay application. Because if they didn't participate, that issue would never get determined by the English court if he only brings the claim in relation to the 650.
Well, you always have that problem with
Yeah.
foreign party who seeks to arbitrate, and you may or may not be able to get some anti-suit relief. That doesn't really help us with.
But the only way,
with the issue we've got.
if you're faced with that dilemma as the consumer who has these mandatory rights under English law, the only way to be certain that the English court, which is the only place in which those rights are mandatory, will determine that issue, is to make a claim for a determination of that issue. Because you can't be certain that the defendant will turn up or contest that. And so you claim a declaration, and then you get the declaration that you want, you can take it to New York and ask the arbitrator to respect that.
Well, you're no better off with that if he hasn't turned up than you are with the declaration of non-liability if he hasn't turned up. I'm not sure the defendant not turning up really adds anything one way or the other. But
it would be a strange result if this case turned on drafting, as opposed to the substance, which is what is the claimant trying to do?
You mean drafting of the claim you've chosen to bring?
Yeah, and as opposed to the substance of what the claimant, the rights that the claimant is seeking to protect.
Well, can I just leave you with this thought, and you may want to come back to it at 2 o'clock. It may not just be a question of drafting, because when one talks about the right to sue and be sued here, if that means the right to have your substantive obligations and rights determined by an English court, then it may be relevant whether that is something that the claimant is asking the English court to do. What Mr. Soleymani is doing is not saying, I would like the English court to decide whether I have to pay 650,000 or not. He's only saying, I don't want it to be decided in arbitration. And it may be said that therefore it's not just a question of form, but the two can only go hand in hand together. If on the one hand you're asking to vindicate your consumer rights, that is to say, the right of someone domiciled here to have the English court decide the rights, if you seek to do that, as we've discussed, you don't actually run into the arbitration exception at all. But if you don't seek to do that, and you bring a narrower claim, which is entirely negative in its focus, then it may not be so surprising that that's caught by the arbitration exception. I just throw that out for you to come back to, if you'd like to.
Well, I'm sure that my client would be more than willing, I'll take instructions on this, to amend to bring in all aspects of the dispute in the English proceedings.
Well, that might face some objections. We've got to decide the case on the way it is before.
Of course. But I'm just saying that he doesn't wish the matter to be determined in the New York arbitration, and therefore I'm sure I'll take instructions that he'd be willing to, in due course, to amend to bring everything in, if we win on these issues before the court today and tomorrow.
Having interrupted you, is that a convenient moment?
Yes, and can I maybe just summarise? So I think I've covered quite a lot of, probably all of what I wanted to say on my first argument, which is why just looking at the claim and looking at the arbitration exception and the authorities on that, the arbitration exception doesn't apply. The next argument is that this is a case in which the court should summarily determine that the arbitration agreement is invalid, and for that reason hold that the arbitration exception doesn't apply. And that's the point I will come on to after the short adjournment, if I may.
Well, at the risk of giving you more homework over the short adjournment than that which you already have, I certainly would think myself would appreciate a little bit of assistance on what meaning you give to section 15A(2), and in particular the words "the nature of the proceedings," which differ from your point, which is the nature of the right to be protected by the proceedings, which I think is what we saw in West Tankers, effectively, I think, if I got it right. So anyway, but it's just I'd like you to help me just understand what, if anything, is added by those words?
Well, I can say now that we have thought about that, and we couldn't really think of anything that was added by it. It's not very clear, and ultimately, I mean, I did consider making submissions on that area, but because ultimately concluded that really what they were saying is you've just got to look at Article 1 of the recast regulation.
But that's not only concerned, is it, with the arbitration exception? It's concerned with all the exceptions. And
yes.
The Article 1(2) refers to certain types of proceedings. So it may be, I don't know. And those are two alternative formulations which apply depending on what one's talking about. If it's insolvency proceedings, it may be the nature of proceedings. If it's arbitration, it may be subject matter.
And of course, we're focusing on the exceptions, but before you get to the exceptions, there's paragraph 1 of Article 1, which tells you that most civil and commercial disputes are within the scope. But obviously things like administrative law and so forth are outside the scope. But the interesting thing about the exceptions, which you've put your finger on, is that arbitration is almost unique in the sense that it's just one word, but it's a process rather than a subject matter, because most of the exceptions are subject matter exceptions rather than a form of the proceedings exception, if you like.
I wonder whether insolvency proceedings
That's a sort of borderline one where it's partly subject matter and partly process.
I mean, this may be a point that helps you, because you seem to be assuming that the "and" in 15A2 was cumulative, and you were met with the argument, which sounds to have some common sense, at least at first blush, that can't have been intended to narrow the position. But it may be that it occurs to me that it's a disjunctive and sometimes the relevant test is nature of the proceedings, not for arbitration. Sometimes it's subject matter, which is more opposite for arbitration.
Yes, because some of the exceptions are types of proceedings, like arbitration or insolvency, but most of the exceptions are subject matter exceptions.
I think arbitration is a subject matter one.
Well,
we're not looking at whether the proceedings in question are arbitration proceedings. Anyway, there we are.
I'm going to start the ball rolling at 3 minutes past 1. Sorry about that.
2 o'clock.